Dummy Guide on how Article 8 of Malaysia Agreement 1963 can enforce IGC report. Article 8 of Malaysia Agreement 1963 expressed that the governments of the Federation of Malaya, North Borneo and Sarawak will take such legislative, executive or other action as may be required to implement the assurances, undertakings and recommendations contained in Chapter 3 of, and Annexes A and B to, the report of the Inter-Governmental Committee signed on the 27th of February 1963, insofar as they are not implemented by express provision of the Constitution of Malaysia. Based on Article 8 of Malaysia Agreement 1963, the governments of the Federation of Malaya, North Borneo and Sarawak can take legislative, executive or other action as may be required to implement the terms and conditions that has been agreed in the IGC report. Any terms that has been agreed in the IGC report which are yet to be implemented by express provision of the Constitution of Malaysia can be implemented by each of the governments concerned either collectively or individually through legislative, executive or any other action. Article 8 never make a provisions or said that the implementation of the agreed terms can only be done by the partners together. But rather, the flexibility was made on which each government individually can take any actions required to implement the agreed terms. The example of this mechanism is the passing of Immigration Act 1963, Act 27-1963, by the Federation of Malaya to amend Immigration Act 1959, which was made in compliance with paragraph 16 and Annex A, Item 1, of the IGC report. As another example, to implement the special interest of Sarawak on education, individually, the government of Sarawak also can take legislative action through primary legislation in the Legislative Assembly to pass, for example, Sarawak Education and Libraries Ordinance, Sarawak Universities Ordinance, Sarawak Education, Student Loans Ordinance etc. The executive actions that has been made by Sarawak government so far on our education rights is the formation of the Ministry of Education, Science and Technological Research. However, with proper legislation, the ministry can implement and discharge their duties more efficiently with clear jurisdiction as the ministry and department created thereof will be constitutionally empowered to do their job.